But anyways, getting to the news this week, we have a pretty big ruling out of the Fifth Circuit. This one's, I think, going to be pretty controversial for the foreseeable future because the Fifth Circuit Court of Appeals just struck down the federal prohibition on people subject to domestic violence restraining orders from being prohibited from owning guns. If you want to tell us a little bit about what went into that decision.
Yeah, so there was a 3-judge panel in the Fifth Circuit that ruled unanimously against this federal law that bars people under a domestic violence restraining order from possessing firearms. And they found that it was unconstitutional under the Bruin standard. They said that the government didn't provide any historical analogs that were similar enough to the modern prohibition that they could stand under the Second Amendment. So this is obviously a fairly significant ruling. It's the first time we've seen an appellate court rule on this prohibition since the Bruin case happened. And I think it's going to have some it's going to lead very quickly, I think, to Supreme Court review. That's my guess. It's sort of fast tracked now for the Supreme Court to take up because it's very likely that the government will appeal this decision, similar to when we talked about the bump stock ban being overturned in the Fifth Circuit as well. That the bump stock ban ruling was an en banc ruling. It was the full Fifth Circuit court. This is just a 3-judge panel. You still have the option of going to the full Fifth Circuit court to hear this case on appeal, or you go straight to the Supreme Court, I believe, if the government wants to. It's obviously one of the thornier questions, I think, that has been raised thus far. Gun rights groups were not involved in this case. Neither were the gun control groups. This was a criminal case where somebody who was charged and actually convicted of violating this law appealed that conviction under the Bruin standard, and this was the result of that appeal. There was actually the Fifth Circuit reversing themselves. They had previously upheld this prohibition under the older standard of review that had become popular between Heller and Bruin, where you had this sort of 2-step balancing test, and the Fifth Circuit had upheld the domestic violence restraining order prohibition under that test previously, but now they've correctly determined that they can't use balancing anymore. They can't balance the interests of public safety against the Second Amendment right. So now they have to use this history and tradition standard to evaluate these sorts of cases. And at least according to this Fifth Circuit panel, that prohibition doesn't survive.
Yeah, no, and this is just sort of the latest that we've seen, I think, sort of the less appreciated ramification of Bruin. I think most folks would consider. A lot of gun control or gun rights advocates obviously thought of policies like assault weapons bans and concealed carry bans were going to be the things that were going to be overturned after Bruin came down. But, shortly after that decision handed down, I wrote a members piece talking about how, criminal justice advocates and federal public defenders were starting to use this law to overturn convictions. And it's just gone crazy, I think, in the time since that's come down. And this is just the latest example of that.
Yeah, there's been a lot of crazy in the sense that it's been very busy. Yeah,
right.
There's been a lot of these decisions out of the criminal side of things, which makes sense, right? I mean, obviously the gun rights groups have their strategic plans that they're going after certain laws that they find highly objectionable, and they're pursuing those cases. But at the same time, you have the entire criminal justice system that is where these defendants and their lawyers are acting independently, using the same standard. And so, we get focused on a lot, I think, in political media on the first part of it, right, on these sort of organized efforts to go after different gun restrictions. but there's sort of this it's much harder to follow the other stuff because it's individuals, and so a lot of times you don't hear about it until a ruling gets handed down like this, and it can be a very impactful ruling. I think this is probably going to be a case where the court is the outcome is much less certain if it is to reach the Supreme Court. Now, first, I said this is a fast track, probably, right? Because the court oftentimes will take up appeals by the government when it deals with federal law like this, because you don't necessarily want a situation where federal law only applies in certain parts of the country, right? And so that's what's happening right now with this Fifth Circuit ruling. In the Fifth Circuit, which covers Texas and Louisiana, the federal government can't practically apply this prohibition, but they can in every other circuit right now, because nowhere else has seen this sort of ruling yet. So oftentimes, though, the Supreme Court has a lot of deference to the government in taking up these sorts of appeals. That's why I think it could happen quickly. However, it is also possible that because there isn't actually a circuit split yet under the Bruin standard, there's a circuit split in the sense that the Fifth Circuit now has a different position on this prohibition than every other circuit, but that's only because every other circuit hasn't heard a case like this under the Bruin standard. And so the court may want to wait for the other circuits to weigh in first and see how they handle this question, because it is going to be an interesting question. I think the history analysis in this case was closer than in a lot of other cases that you've seen. A lot of the federal judges that have upheld various gun restrictions to this point have done so less on the actual finding of a solid historical analog and more on, the argument that some part of the what's being foreclosed by the law is just not protected by the Second Amendment. You see this Oregon, even though the state court there blocked the new gun control law that was passed by ballot initiative, the federal judge was prepared to let that go into effect, in essence, because she ruled that for instance, the magazine ban that they're putting in place, she ruled that magazines aren't protected by the core of the Second Amendment, like they're not arms. It was one of her reasonings, and so that's been a common way of trying to uphold these various gun laws under Bruin. But in this case, they went through the historical analysis and they determined a couple interesting things, and I think that they were much closer to finding a historical analog than in a lot of other cases. First off, they looked at a couple of things. The government offered up a couple different historical gun regulations as potential analogs. There was, dangerous people prohibitions, the sort of stuff we've talked about before on this channel that include, of course, bigoted laws against African Americans and Native Americans, just sort of total gun bans for them altogether, but also there were bans for people who wouldn't take pledges of allegiance or people that were, and then they went sort of further back into English history where people could be disarmed if they were thought to be, a danger to the crown or to the people or what have you, and so they started with that. Then there was the prohibitions on going armed to the terror of the people was another one that they cited. And then, of course, they brought up surety laws, which required people who were accused of being dangerous in a civil proceeding to post sort of bond or surety if they wanted to carry their guns in public, to sort of insure against them causing problems was the idea. And those laws were fairly common at the founding era. And of course, the court rejected all of these comparisons, mainly for two reasons. One was they didn't fit the purpose of the domestic violence restraining order prohibition. So the purpose of that is to protect keep somebody who has been identified a potential threat to another individual from causing harm to that person. And that's not what any of these other laws had done, or at least not the the dangerousness law, sort of dangerous groups of people. Those were aimed at groups that were considered to be dangerous, whether for bigoted reasons or otherwise. And then to go to the terror of the people, being armed to the terror of the people was something that required a conviction, and also was meant to protect the general peace, not specific people. Again, that was another thing the court pointed out as a difference. And of course, the surety laws were much closer than the other two, according to this Fifth Circuit panel. But even there, the main problem was, even though these were civil proceedings in both situations and not criminal proceedings, they don't require convictions. The surety laws only required that somebody post a bond, basically post a surety to carry their guns in public, whereas the domestic violence restraining order prohibition takes the person's guns away altogether and bans them from possessing them. So there were a lot of closer calls, I think, in this case than in some of the other ones, if that makes sense.
Right. And I think that's going to be interesting if and when the Supreme Court decides to take this issue up, is that I think it'll cause maybe the first real stress test of the new Bruin standard, because as we've seen in previous Supreme Court decisions on the Second Amendment, notably Heller, the dicta that the court has offered up seems to suggest that they just seem to believe automatically that certain dangerous people are allowed to be prohibited from owning guns, but it's never really been put to this Bruin test. And if they decide to take this case, it'll be the first time that they really have to kind of square that circle then to show how this does fit, in fact fit, or maybe the dicta that they previously offered up was wrong. We don't know yet.
Yeah, I think that's the other big point here, which is that the Supreme Court gave down this standard in Bruin that would seem to implicate a lot of laws that the Supreme Court itself has indicated they think are constitutional. For instance, like you mentioned there, bans on machine gun sales or ownership. New sales of machine guns are illegal in the United States now. And that's from a law that was created in 1934. It's not an old law. It doesn't go back to the founding era. And it's unlikely that you could find a historical analog for that law. And yet, the Supreme Court has implied that it's constitutional in Heller, at least in dicta, which means in writings that aren't to the core of the holding. And same thing with felon in possession laws. They've said that those are presumptively constitutional. At least they've said that Heller doesn't implicate them directly. And there's another one where there's at least an argument to be had about what the historical justification for those laws are, which again that comes from the Gun Control Act of 1968, which is again not a historical law. And there's all sorts of things like that. And same thing, even in Bruin, there was concurrence from Roberts and Kavanaugh that talked about how they shall issue gun carry permits as constitutional, as presumptively constitutional. And there's the same thing there. Like, where's any sort of permitting to carry a gun during the founding era? I don't think that it existed at all. And so you have what the Supreme Court has handed down in their standard in Bruin, and then you have what the Supreme Court seems willing to actually do. And they may be two different things. We don't know that. That's the thing about Second Amendment jurisprudence at the Supreme Court. It's very limited, even still. They only had a handful of cases, 4 or 5 cases, really, if you count Miller, which they do use in Heller as a basis. So, that's what 4 cases with Saitano, right, that directly deal with the Second Amendment. And you got Miller, Heller, McDonald, Saitano, and Bruin. So 5. And, how many First Amendment cases are there? There's, dozens and dozens and dozens, hundreds probably. And so there's still a lot to be learned about what this court is going to do with these sort of controversial rulings, these controversial situations. Because to this point, as we've talked about before on the show, they've really only gone after things that are really wildly popular. So Heller is about handgun ownership. You can't ban handguns, which is a position that the general public was way ahead of the Supreme Court on. And then Bruin is about how you can't ban gun carry or effectively ban it, which again was something the general public was way ahead of the Supreme Court on, because there were only 8 states that had a ban on, or had like an effective ban. They may issue laws by the time the Supreme Court got around to Bruin. So things like domestic violence, restraining orders leading to prohibition, probably a lot more popular than both of those previous tests, right? Those previous laws. And that's where you start to wonder what the court is actually going to do in that situation. Now, I will say that the lower court in the Fifth Circuit, they seem to have, one of the key issues in this case seemed to be that it was a restraining order that can be granted through civil proceedings and not through criminal convictions, where people are afforded more protections for their rights and the standard of evidence is higher. So maybe the Supreme Court also views that distinction as important in this role. But we'll have to wait and see.